Good evening. I'm John Batchelor. This is The John Batchelor Show. Mary Kissel, the editorial board of the Wall Street Journal and the host of Opinion Journal each day at 1 p.m. and then all the time on video afterwards at WSJ.com, joins me. Mary, a very good evening to you. We have late news of the Tsarnaev brothers and the attack in Boston. You very much have been covering this on Opinion Journal these last days, and you had an important piece on the op-ed page of the New York Times today, written by Judge Mukasey about the
Wall Street Journal.
The Wall Street Journal, excuse me, written by Judge Mukasey about the Tsarnaev brothers, and particularly about the Miranda rights that were read to Joshkar Tsarnaev 16 hours after the FBI had started his interrogation. I thought Judge Mukasey had some excellent points, and we're going to speak immediately on those to our friend Ed Hayes, of an attorney at law, a criminal defense attorney in New York, and my consigliere. Ed, a very good evening to you. We must get to this because the breaking news out of Boston is that Tsarnaev brothers, this is the remarks of Joshkar Tsarnaev, we can believe while he was being interrogated by the FBI, since the Miranda rights were read, we're told that he has stopped talking to any authorities, said that they originally planned to attack on July 4th, that because they built their bomb faster than they expected in the Tamerlan Tsarnaev's apartment in Cambridge, they accelerated their plans to the April 15th strike of the Boston Marathon. There's also the suggestion that Tamerlan Tsarnaev's now widow, Russell, may have participated in the building of the bomb. There are pieces of evidence, fingerprints, DNA found in the bomb fragments that suggest a woman was present. She has stopped cooperating with the authorities. My leading question to you, counselor, right now, the decision to read the Miranda rights to Joshkar Tsarnaev, has that in some way abridged the FBI investigation? Has that hampered law enforcement in all directions at the possible scale of the number of people who knew what was going on? Good evening, Ed.
Right. It's all a question of how long you wait. And, I mean, really, if you're going to take it to a certain level, you'd say, look, give him a beating and see if he talks. I'm not a big fan. I mean, I think that the public protection is a good idea. But I'm not in favor of an American citizen giving up, say, well, he doesn't have any rights because he's involved in terrorist activity, because who knows what's a terrorist and who knows if he's guilty or not. Suppose you find out that the guy, his role was minimal, or say you have some guy in the Midwest and you say, well, we found a house full of guns, maybe he's some other militia terrorist. I just think, I agree that you need a public safety exception. The question is how long it's going to last. Here they had, 16 hours?
That's what they're telling us, and then they stopped because of the Miranda rights.
Frankly, I think they could have gone on a bit longer, because 16 hours, the guy is very wounded, and I don't know how much information you're going to get out of him when he's still groggy. So it wouldn't have bothered me if they'd say, well, look, we're going to let him get back in some kind of condition to talk intelligently, and then we're going to take another 24 hours. They may have jumped the gun a bit.
Ed, I draw your attention to the Judge Mukasey piece that was on our op-ed page this week. He talks about the case law on warrantless arrests requiring the initiation of a court process within, as you say, 48 hours. But then he makes the case that the exceptions to that really don't apply here. And it's not that they don't have any rights. I don't think that Mukasey was arguing that Joshkar Tsarnaev should have no rights. I think what he was arguing is that there was more flexibility in the law that the administration could have exercised if they had chosen to, and that they didn't explore any of that flexibility at all. What did you make of that piece?
I thought he had made, I thought it made some sense, frankly. I mean, he was very critical of Obama, well, first of all, what Obama did do is, right after he came into office, he said, look, you can't torture people, which I agree with.
Right.
And then as part of the public safety exception, Mukasey had some sense. A big part to me is he was badly hurt. Now, if you're using that pain as a way to extract information from him, I don't know how I feel about that. But certainly you should have some significant amount of time to talk to him and to ask him questions after he is able to talk intelligently.
At a lot of these finer points of law, I think, might not be familiar to a lot of listeners, but here's one that Judge Mukasey raised. He said, the Sixth Amendment guarantees the right to counsel in a criminal case, but it guarantees no more. In other words, this fellow might not even have a right to having a lawyer present during questioning to allow them to get more information out of him. What did you... I hear you grumbling on the other side of the phone.
During a period of time that the public safety exception applies, he's not entitled to a lawyer, because if he's got a lawyer there, the lawyer's going to tell him to shut up. All right. So that period of time, I don't think you should have a lawyer. However, 16 hours, 20 hours, whatever. When you say, look, it's not reasonable to have a public safety exception anymore, then he's entitled to a lawyer. I also reject Mukasey's argument that you're really not, you're asking him questions that you're not going to use in the case against him, and therefore that's okay. I mean,
that is what Judge Mukasey says. The Miranda is only to prevent you from using the statements in a court of law for conviction, but it doesn't mean that if you do not use it for the court of law, that you can't continue the interrogation to provide real-time evidence. I want to turn this away from the legalism to what we know now, lad, which is a growing sphere of characters around the Tsarnaev brothers. We have the wife mentioned in the New York Times piece tonight by Eric Schmidt. We also have, we know, 2 or 3 roommates or college friends of the younger Tsarnaev who threw away evidence after they knew that Tsarnaevs were involved in mass murder. They threw away bomb-making evidence and also a computer drive. That's what the FBI is testifying in their complaint filed yesterday. And they're going to Dagestan now. Makhachkala is the capital of Dagestan, where the mother, Zubaida, and the father, Anzor, have been living estranged these last months, years, and Tamerlan visited. We don't know who Tamerlan talked to when he was in Dagestan. Now, the reason I bring all this up is because the FBI is in some way constrained by the fact that they cannot continue to interrogate the living witness, the mass murderer himself, who might have heard things from his brother that he doesn't know the significance of until he's prodded. But they can't talk to him now, Ed.
Well, okay. I mean, there's lots of times that, you'd like to get intelligence from people. For instance, you pick up a serial killer.
Right.
You'd like to know if he was working with anybody. So it's not as if they just invented this issue. Okay. Let's talk about where I agree, which is that public safety exception, whether or not you should have a more reasonable period of time to do that, especially when the kid is hurt.
I go along with the 16 hours, public safety, but it is more than a week later now. They have developed information they didn't know to ask about in the first 16 hours.
John, it reminds me of Zero Dark 30, that scene in the movie where the CIA goes to the White House and they say, we have bin Laden, we know where he is. And the White House responds, well, give us proof. Can't you ask somebody if he's there? I'm summarizing. And the CIA says, well, you decimated these programs. There's no one here to ask. It's a very similar situation.
And finally, all right, you're being fair-minded about this. I will as well. Right now, this is lessons learned from Boston. Can we say one lesson learned is Miranda is about a court of law, but it's important to apply what we know about interrogation of terrorists independent of Miranda? Is that a lesson learned, Ed?
I think the lesson learned is we got to have some clear plan of what we can do and we can't do. Right now, it's entirely too gray an area, which I think is a mistake.
Ed Hayes, attorney at law, defense attorney at law. We're debating something that we must learn from because, guaranteed, Mary, the Tsarnaev brothers are not the last of these jihadists who will strike at America.
No, and President Obama dismissed the interrogation team, so another lesson learned.
Mary Kissel, editorial board of the Wall Street Journal and the host of Opinion Journal each day at WSJ.com at 1 p.m. East Coast time, Australia, and I'm John Batchelor.